and pushed the complainant against the wall, causing pain. He's going to beat her mom up and kick the door open and kill everyone in the house. So stated he has nothing to live for.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man.
Welcome to Bench Report Court Cam.
Did you say
Richard, page 26.
Good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against the wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay. Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No. I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer, and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right? Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a receipt of Victoria. We'll have you skip in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge.
No, I have it on file. Thanks. Yes, ma'am.
Judge, I got appointed to Mr. Richard today. It's R-I-C-H-E-R-T.
Yeah.
And he has no contact as part of his conditions in a
Correct.
MOAP. He does have two daughters with the complainant.
Court comes to order. We need to talk them out.
He wants to know if he can still go there for visitation
No, she doesn't want him to come over. That's what I heard. Right?
Say would be a.
Well, Judge, would you at least allow him to get a third party to pick up the daughters?
I mean,
Okay.
come up.
Maybe we could do that as sort of a middle ground.
Is it Richard or is it Reichert?
Richard.
Mr. Richard, I like to follow the wishes of the complaining witness. So if she doesn't want to have contact with you, then that's what we do. If she wants to have contact with you, then I'm fine with it. But I have to hear it from them to see what they want.
Okay.
What the state has told me so far is that they don't want, this person doesn't want to have contact with you. The last thing I want is for you to go over there. You accidentally bump into her, words exchange. You're the one that's on bond. You're the one that's going to end up going back to jail. So it's more of like a preventative measure, right? So there's no issue if you have someone else to try to facilitate contact with your daughter. The complaining witness is only the ex-wife. It's none of the daughters, right?
Correct, Your Honor.
Right. So however you want to have contact with the daughters, great. Just don't go over there. You can always use someone else to try to like be an intermediary to get them to you however you want.
So someone else could go pick up my children and bring them to me.
Sure, of course. Yeah. But that's probably the safest way so you don't bump into this person. She says something to you where it just inflames the passion and, that's the last thing we want.
Is someone going to explain to her that someone else will be picking up my children? If I'm not allowed to
I guess,
contact her?
can you reach out to her and let her know that that's what we're going to try, that's what they're going to try to do so that she's aware of, even leaving however you want to. Yeah, we'll have the state reach out to her to let her know that this is how the agreement that they're going to try to work, so to have someone.
Okay.
How old are the daughters?
8 and 14.
Yeah. Yeah. Do you mind, please? Yeah. Okay. So they'll reach out and do that. And then, hope maybe a grandparent or someone else or
They're worse.
Okay, well,
Thank you, Judge. Appreciate it.
for sure. All right. Anna, you were Dedrick Addison?
No.
No, Judge, they didn't come up. Page 6, bottom of 6.
Mr. Cogdill?
Yes, sir.
Sir, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 1st, 2024, the officer is dispatched to a terroristic threat call in Harris County, Texas, and the complainant and the defendant have an on and off dating relationship. The defendant is also the father of the complainant's child. The complainant stated they got into a verbal argument and she recorded it. The officer listened to the recording and the defendant stated he was going to beat her mom up and kick the door open and kill everyone in the house. The defendant also stated he has nothing to live for.
Mr. Cogdill, I'm going to find that there's probable cause to go forward with your case. Do we know if she wants to have contact with him or not?
Let me see if a rip has been. Your Honor, there's been no contact made as of now.
Until I know that this person wants to have contact with you, I'm ordering you not to have contact with this person and not to be in possession of weapons. Do you understand?
Yes, sir.
Just be good. It's not hard, you know. Would you like me to provide you a lawyer today?
Yes, sir.
Okay. Would you mind filing no contact, no weapons?
Yes, sir.
Please? I'm going to give you a lawyer today. Just don't pick up any new cases. Be nice. That's all we're asking you to do, you know?
John.
Really. I'm going to have you sign a reset, Victoria. Let's see. I have an application on file already. So what I'll have you do is I'll just have you take a seat in the jury box. Wait to get your lawyer. I need you to sign these bond conditions as well, and then we'll go from there. All right? Please, sir.
Right this way.
Ready? Come on up. Yes, sir.
Judge.
It's a brutal Friday.
No.
What? All right. Done though. All right. Hi, guys. Tell me what's going on.
Yeah, over here on Deontay Huggins.
Huggins. You were Mr. Jointer, right?
I am, Your Honor.
Okay. So tell me what's going on.
So he is, as the court is aware, out-of-state fugitive. He has waived his extradition. We were here to see if the court would entertain giving him essentially an extradition bond.
Okay. Do you mind bringing out Mr. Huggins, please?
I'll get that.
Either or, whoever. Ms. Donaldson, is this an arraignment?
No, Judge, this one was you rolled it to today because we were supposed to be trying to get proof of I'm sorry, I'm at the hospital with my grandfather. We were trying to get proof of him being in Spring Hills.
I'm sorry about your grandfather.
Thank you.
Did you get anything?
We got a letter from them, but I think it might be the same one that was sent to you all, and it just said that he was there with no discharge date, and that was pretty much it.
Let's see. Let me see what, did you get it or did Victoria get it?
I'm sorry, you said that
The letter you said that you guys got, did you get it or did Victoria get it?
she sent one to me. She said that she sent one to Victoria. I'm not sure if it's the same one. If not, I can forward it over.
Give me a second. Let me see.
Okay.
Hunt.
Huh?
Remember, this is the one that they said it's in a facility, but we don't have proof. We don't know.
That's the one that, I think I sent it to her what I had. It was just something from the mom, like you said it was.
Get something new?
Oh, no, no.
No, we haven't gotten anything new. I don't know. I need some kind of proof, not just their word, you know?
Okay, I can send over this document that she sent me, and then
Sure.
Would you mind sending it to Victoria and then she can print it out for me, please?
yeah, sure, I can do that right now.
Thanks.
No.
Good morning, Mr. Huggins. So understand that your lawyer is here because he wants me to set you a bond. I don't know. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, What matters to me are two things. Number one, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this case here, this is a new case.
Yes, Judge. It was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor,
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter, out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22, 23?
Yes, Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secure.
This is that, it's such a short time. He's picked up this case. He's picked up, I guess, a weed case, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond for did they file a motion to adjudicate on the
aggravated robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently,
No,
yes, Judge.
And it was dismissed because the Brennan marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun, and I don't know if there's shooting involved, but the good news is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So you said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, in was it Lafayette?
Is East Baton Rouge,
East Baton Rouge.
Currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so I can't speak for the trial bureau, but if they decide to revoke.
Huggins, you got to understand, when you're on felony probation, something like that, you got to live with a halo on your head because you could be looking at 20 years, man. All right.
Thank
Thanks.
you,
Thank you, Judge.
Yes, sir.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.